right? And for that, the first thing that we all need to do is to say, we will not make assumptions. We will unlearn everything that we know about the world, including about colors, because this happened to be a very famous dispute between T-Mobile and AO Cellular, where the color magenta was sought to be protected by virtue of enforcing it against the rival brand which was using the color plum, right? And the argument that the defendant took was that the human threshold for distinguishing colors, these two colors ensured that it was 20 times higher than the normal human threshold, and they brought in expert evidence to make that statement. And the plaintiff in turn brought in a professor of cognitive sciences, Donald Hoffman, who came in and said that though there are obvious differences, human beings remember colors by way of memory, and if somebody has to recollect it by way of memory, this distinguishing elements may not be very obvious, and the plaintiff eventually prevailed. Right? The reason why I'm saying this is that you can never assume that the expert evidence is not required, because something as similar as colors can require you to bring in expert evidence. Right? So unlearn everything you know, and I think that's the first lesson when it comes to expert evidence. So first things first, I think it's important to know the unknowns. Colors, I would have presumed that it's obvious to the naked eye, I don't need experts. But I need to know now that if somebody disputes the similarity or the dissimilarity of the colors, I might have to bring in an expert. But how do I know which expert to bring in? For that, I need to know that the relevant field is cognitive sciences. Right? So sometimes the job of the lawyer is to be able to know just enough about the world to say that this is the subject that is relevant and this is the expert that I need. The other thing is that expert evidence could be very important when it comes to assessing cultural relevances in IP disputes. We had a trademark infringement matter where the defendant had taken the defense of descriptive fair use, saying that the mark is descriptive, my usage is descriptive in the ordinary course of the English language. And we had to bring in evidence from English grammar to show that the ordinary rules of English grammar would not permit this as fair use in the language. Therefore, the use was in the nature of use as a trademark. Right? Again, I've grown up in a school that taught me in English. I have spoken English all my life, but I could not take this for granted, and I had to pick up the Wren and Martin English grammar book and probably get in somebody who could explain this to the court. Right? So sometimes cultural elements also make a difference, because a judge in an English jurisdiction will be able to very readily appreciate it, but a judge in a non-English jurisdiction might need an expert to explain what is the descriptive fair use. So culturally also sometimes you need linguistic experts to come in. Right? The other famous example I can think of is, how many of you have heard of the song Shape of You by Ed Sheeran? So I presume everybody, right? So that was the subject matter of a very big copyright infringement claim. And one of the experts that managed to make the difference was a musicologist who could compare the notes in both the songs and then explain to the court whether there is similarity or dissimilarity. Right? And last but not the least, for assessment of damages, especially because valuation of IP is a very tricky subject, more so when it's a trade secret or confidential information, because market comparables can become very, very difficult to ascertain. You will need an expert to come in and depose before the court as to the extent of damages. The other area is a very particularly contentious area of trade secret litigation called residuals, which is when an employee who has gained certain skill set and experience in the field of technology inevitably carries subconsciously some amount of his employer's IP to the next employer. Right? It is retained by unaided memory, but nevertheless there is a clause in the contract that says even that is owned by the previous employer. Now, to determine what is the extent of similarity between the two trade secrets, you will often need the help of experts who can depose regarding the tech similarities. What is the science behind it? Now, obviously, expert evidence is only as good as A, the competence of the expert, B, the method of science that they have employed to come back and depose before the court, and that becomes a source of cross-examination. Right? How is the person competent to depose on a particular subject matter? The statistical assumptions that he has made in a valuation report, are those assumptions correct or not? Right? Is he culturally sensitive enough to come and depose on matters of, say, language or local culture? So these are some things that we'll have to look into. And one experience of mine was a case where the plaintiff alleged that their mark is famous. They got in a very, very big valuation company to come back with a report that said it is a famous mark or a well-known mark. And when we went through the report, The report also makes reference to their understanding of a well-known trademark, which was completely contrary to the legal definition, right? And the entire report, which came at a cost of $250,000, was set aside in a matter of few minutes, right? So oftentimes the fundamental assumptions and the science behind the expert evidence, that's where you look at examining whether it's credible or whether it can be questioned in cross-examination. So at the story of Stephen Schwartz really scared me. So these are my references, right? The magenta and the plum case you'll find in a book called The Case Against Reality: How Evolution Hid the Truth from Our Eyes. It's a lovely book on cognitive sciences. And this is my contact information. Thank you very much.
Thank you. Thank you very much. I think we can open the floor to questions now. Does anyone have questions for the panel?
Advantages of after the lunch. Everyone is sleeping.
Questions, please, if any, or if you would like to contribute something.
I mean, ideally, we've convinced you all that arbitration is a great dispute resolution tool. So, if there are no questions, though, feel free to come and see us in the next break. Go for it.
Can you tell a bit about the cost of arbitration versus litigation?
So, if I understand correctly, the cost of litigation and arbitration, right? The comparison. Basically, the cost of arbitration is lower because it goes quicker, and there is no appeal process. But if it's a litigation, there is first instance, second, third. So it's a much shorter process, but that really depends case by case. In some very complicated cases, arbitration can be more expensive because you not only need to pay the attorneys, but you also need to pay the arbitrators, right? So generally cheaper, but really depends on the case.
So that question is actually quite a complex question to answer, because if the forum of arbitration is, say, the Dubai International Arbitration Center, and the disputing parties are, say, Indonesian and European, for the European person it is probably inexpensive to go to arbitration, but for the Indonesian it is very expensive. So I think you will have to look at a variety of factors to determine when arbitration is expensive and when it is not. Is it quicker? Perhaps yes. But is it more expensive? I think that question requires a much more layered analysis.
Sure, one more question.
Yeah, my question is how often you see that IP disputes in pharmaceutical sector being sorted through arbitration?
Maybe I'll take that question myself quickly and then open to the rest of the panel. So I was involved in a really huge IP dispute, IP arbitration last year that was in the pharmaceutical sector and involved 3 different jurisdictions. It spread across Japan, Europe, and the US. Had to do with the licensing agreements for the development of a drug, and different competition law claims as well, and it was several billion dollars in amount, and we touched on loads of really technical questions regarding who had actually contributed more to the development of the drug, whether the licensing fee was still appropriate or not, whether certain local laws prohibited the licensing fee from continuing to be paid, etc. So it's highly complex. We had a huge team across offices, across different teams, arbitration team, competition law team, different local laws. And yeah, we see more and more disputes like this actually coming to arbitration, and it was a terrific way to resolve the dispute. It was fast, it wasn't more expensive than litigation, and the client was very happy with the resolution. So I would say yes, but I'd like to hear. Yeah.
So I think, especially in the pharma sector or any kind of sector which is heavily into the R&D and science and technology, especially for resolving matters like who actually owns the IP, right? Or matters of say confidentiality or matters of that nature. Arbitration can be reasonably common, especially when there's a pre-existing contract between the parties, and it becomes even more attractive when you have the parties litigating the same cause of action or similar causes of action across different jurisdictions. So we were in a software licensing dispute where one litigation was in Canada, one was in the US, and one was in India. Now, a very easy way to ensure that you don't have contradictory decrees is to ensure that all of those disputes are consolidated and brought before an arbitration forum. So I do think that in the R&D sector, especially when there are underlying contracts, IP disputes can be reasonably and very effectively arbitrated, right? And it's very effective also.
So any dispute between the branded and the generic, specifically for the trade risk, have you came across any such?
So that I don't, at least in India, I haven't seen too many of those kind of cases going to arbitration for the simple reason that not always is there a private contract. It's usually through the channels of a compulsory license, number one. Number two, the other problem being that oftentimes it involves determination of rights which are matters of public policy. So for example, the patent evergreening dispute that the Indian Supreme Court adjudicated concerned cancer patients not just in India but around the globe, especially in the developing world. So in those kind of cases, the Indian courts have been very conservative in terms of advocating for arbitration.
I'll just add one thought to that, which is just remember arbitration is contract based, right? So that's what Ashok was just saying. And if you have any sort of agreement, be it a licensing agreement, a developing agreement, then you can actually put an arbitration clause in there. If you're in a situation where you don't have any agreement, like between a branded and a generic, then you can still go to arbitration if you reach an arbitration agreement with that party. So say you see that there's a dispute coming up, your natural forum would be litigation, but you approach the other side and you say, hey, wouldn't it be more efficient for us to arbitrate this dispute? Do you want to enter into an arbitration agreement with me now so that we can take it to arbitration? That's an option.
And in my experience, nobody ever agrees to the request, right? Because you want to frustrate the other party as much as possible.
But for some time I've seen that they're not for the patent but for the trade dress specifically.
Trade dress, unless there is an agreement, it's not arbitrable.
So if I could add something, well, generally, as I said, arbitration of intellectual property disputes is underused, especially when it comes to infringement and validity issues. But for agreement type of disputes, yes, I personally handled a deal, which is a Belgian client. I think it's a university 3 years ago. It's a licensing deal between it's a university in Belgium and a Chinese company. So in this deal, in this licensing deal, and the client want to make it clear, the dispute resolution mechanism is arbitration, and the parties are stuck with two arbitration institutes in China, whether it's CTEC or Beijing Arbitration Institute, and we did research. So this goes to the selection of arbitrators. And we found from the arbitrators list, there is one arbitrator, if I remember correctly, listed in CTEC, which has profit background with this deal. It has university background. It's a professor, and it knows about IP, about life science, and so finally we choose this arbitration institute as a venue for possible dispute resolution. But if we are talking about non-agreement type disputes, if it's infringement or a validity issue, not very much. We do see some high-profile non-agreement type of disputes, but mostly standard essential patents